You're trying for this thing right here is the problem. I can't see. Okay, on the record in the matter of the people of the state of Michigan versus Kathleen K. Bearden, file number 23-02209, council appearance.
Kayla Crino, appearing on behalf of the people.
Good afternoon, Your Honor. Derek Hogan on behalf of Kathy Burden.
Okay, thank you. Today is the date set for a motion filed by your office for a motion in limine to introduce evidence relating to Van Langeldel. I don't know how to pronounce his name well, and a motion to compel records. So you proceed with your argument.
Thank you, Your Honor. I think Mr. Somberg on behalf of Sean Maddox is also remote.
I'm sorry.
I think Mr. Somberg is remote on behalf of Sean Maddox, the co-defendant in this matter. I don't know if he plans on joining the motion or what, but he is on Zoom. I just want to make the court aware of that.
Okay.
First off, thanks to the court for being so flexible as it relates to this motion. I appreciate that. I also appreciate the prosecutors in this matter working to resolve a lot of our issues on the front end. I understand that they're in a position where they have to come in and defend decisions that are likely made beyond them. So I get that, and I'm sympathetic to that position. Based on those discussions, it's my understanding that we've really got 3 points of contention. Number one would be relevance as it relates to Van Langevelde's opinions on the 2020 election and on former President Donald Trump. Number 2 would be privilege as it relates to whether it was waived by bringing Van Langeveld on the prosecution's team when he is in fact a fact witness. And number 3 is our motion to compel. So I'm going to proceed in that or in that order, Your Honor, unless there's questions that interrupt.
I'm going to actually speak power just because I have a fan right here, so
Oh,
it's picking up some of my sounds.
Yeah. Thank you, Judge. I will. I'm trying not to. I want to yell. So number 1, my reading of the prosecutor's response is that they're under the impression that we're asserting for some reason that the rules of evidence don't apply. I would just flat out say that's not what we're arguing. We concede and agree that the rules of evidence in general do apply. I anticipate asking questions, and so does Mr. Denini, in accordance with rules of evidence, just like any other witness. So I wanted to get that out of the way. As it relates to the substantive matters, in large part, I want to rely on the pleadings. I think it's laid out in the papers. I just want to hit a few key points. Number 1, with regard to Van Langevelde's opinions of former President Trump, this is going to be lay opinion testimony under 701 based on the facts that come out that are anticipated to come out surrounding the former president's bid for re-election. And under 701, his opinion as a lay witness is permissible, and that's the basis for us questioning him on that. With respect to Van Langevelde's opinion on Trump, it speaks, frankly, to the credibility of the prosecution and Mr. AAG Van Langeveld. It's the defense's position that if former President Trump was not involved in the facts of this case, it never would have been brought. That's kind of a pillar of the defense, and it's our position, Your Honor, that we're entitled to go down that road with Mr. Van Langeveld. He's a critical part of the charging decisions, and the elephant in the room as it relates to the charging decisions is President Trump, former President Trump, and the controversy surrounding him. So it's our position that we should be entitled to question him there. The same goes to his opinions regarding the 2020 presidential elections. He was on the board of canvassers. He made decisions related to certification of those election results. His opinions under 701 as it relates to the circumstances surrounding certification, the allegations that were being made at that time, again, speak to the underlying credibility of him as a board of canvasser and also as a appointee on the state board of canvassers, and also his credibility as a prosecutor on the case. It's also crucial to the question as to whether AAG Van Langeveld was under the impression that certification could have ever been changed under federal or state law from current President Biden to then former president, or to then president and candidate Trump. At the hearing, I anticipate that, or when he's testifying, I anticipate this is going to come up. At the hearing on the board of canvassers, AAG Van Langeveld sparred with a very well-known Republican lawyer on the law and the substance of the law as it relates to the legitimacy or claims that the election was stolen or there were irregularities, so on and so forth. And those statements are his statements. We intend to go into those with AAG Van Langeveld, and I believe under the court rules, that's all fair game. And we'd ask the court to agree. He spoke about his duty under the law. Also, this is going to come out. He did this while, it's our position, ignoring clearly provisions within the law that allow AAG Van Langeveld to do what this particular lawyer was asking him to do. And then the statements that he made while on the board of canvassers were used to bolster his credibility within the media as the one lone Republican that stopped former President Trump. And again, this all speaks to his credibility. Credibility is always an issue, and that's why we intend to ask him about this stuff. There's also several legal bases to support the idea of the alternate elector slate. I've mentioned them in court several times, or in our pleading several times, both under federal and state law. AAG Van Langeveld dismissed all of those alternatives and really focused in solely on a recount, ignoring a new provision of the law that was passed via ballot initiative, among other things. It was passed in 2018. It didn't really come into effect until 2020. Again, those statements are all fair game as it relates to his understanding of the allegations and the credibility, or purported lack thereof, of the election results. That's why we intend to go into that. As it relates to privilege, Your Honor, I generally would agree with the prosecutor's position that a prosecutor's work product is privileged, that deliberative process is privileged, so on and so forth. However, Your Honor, I must point out that in this current circumstance, this case is unlike any other case that can be found in Michigan jurisprudence. I am under the impression, based on our research, that it can't really be found anywhere else where a prosecutorial body takes a necessary fact witness and puts that person on the prosecutor's team. Never heard of it. I don't think it's ever likely happened. Hopefully it never happens again, but that's what we have here. So to the extent that the prosecutor, and I understand, I get the bad or the predicament that they're in, but to the extent that they're trying to draw the analogy from existing case law that usually would shield the prosecutor, Your Honor, it's my position that that just simply doesn't apply because of the uniqueness of this case. By placing AAG on the prosecution's team. It's our position that they waived, as it specifically relates to AAG Van Langenveld's involvement. I'm not saying that they waived all privilege, and I can, go crazy in the AG's office, nothing like that. But as it relates specifically to AAG's involvement with the prosecution's team, it's our position that they waived work product, deliberative process, and all of the privileges typically enjoyed by a prosecutor must give way to my client's Sixth Amendment right to confrontation, including confrontation to impeachment evidence, which this all goes to impeachment. Well, most of it, I would say, goes to impeachment, and the 14th and Fifth Amendment rights to due process. And I'd ask that the court rule accordingly. As it relates to the documents, the motion to compel, it's our position, our theory of it. One of the theories that the defense has here is the circumstances under which AAG Van Langenveld was hired are highly suspicious. The timing of it, the timing or the fact he was brought in as a senior attorney with a salary based on the documents that they produced, $125,000 a year. He's, based on their pleadings, crucial to the prosecution's legal theories and prosecution's team. That's all evidenced in their pleadings when they were addressing the court's sequestration order imposed on AAG Van Langenveld. As charges issued in July, I believe, less than 2 or 3 months later, he's getting a $10,000+ raise. Given the knowledge I have of the Attorney General's office, there's another defense attorney, co-defendant, that also has knowledge of the way the Attorney General's office operates. I would say that's highly suspicious, and we're entitled to explore whether there was a financial incentive into finding the charges that other prosecutorial bodies said could not proceed to do so on behalf of the Attorney General's case.
I just want to make sure I'm following. You're stating he was hired, I guess, in 2023, and he was offered a salary of $125,000 to be a assistant AG, or is he the section head or something?
My understanding, Your Honor, is he's not the section head. He was hired as a 16 senior attorney, and I intend, and that was in February of 23, is my understanding.
Okay, and then since then you're saying he's got a $10,000 raise, in your belief, you suspect that they lured him in for the purposes of finding a way to prosecute this case?
My belief, Your Honor, the defense's position, he was hired specifically to participate in the prosecution of this case based on his participation on the Board of State Canvassers and him being a Republican lawyer. From there, he engaged in the prosecution's team. It's my position that if he didn't write Agent Schock's affidavit, that he had a significant role in formulating what I would say is an incorrect legal theory that supported the charges that issued against my client. And as a result of that, there's a financial incentive, a $10,000+ raise that happened 2 or 3 months as requested by the chief deputy, I believe at the time.
Don't all AAGs get an automatic step increase in 1 year?
Well, it was 9 months, Your Honor. And
It's within 1 year. It doesn't have to be 12 months. It's within 1 year. You get automatic step increase.
You don't get double step increases in 9 months. $10,500+. No.
I don't know about you, but I got 10,000 in my first year when I was there.
Well, Your Honor, our position is it's unusual, and we're entitled to review the documents. And
Review documents about his hiring?
We already had that, Your Honor.
No. What do you want to review?
Yeah. It's also unusual that the Attorney General herself requests these types of significant step increases, it's our position that if we review all the requests under this current Attorney General to now, in comparison, that position will be corroborated by the evidence in the documents that we're requesting.
Okay, so you're suggesting that Dana Nessel herself specifically requested a step increase for this attorney,
It's in writing, Your Honor. It's attached to the brief.
and that it's unusual for the Attorney General to make a request for a step increase or a pay increase for an Assistant Attorney General.
And
For an Assistant Attorney General, and for that purpose, you think that you need these additional documents?
I don't think it's that simple. I think it needs to be viewed, Your Honor, in the context of the political nature of this prosecution and all of the other circumstantial smoke that we have pointing to the fire conclusion that we're seeking. In the alternative, if the court's not prepared to grant the motion to compel, I would ask that the court review the documents in camera and make its determination based on that.
Any other argument?
1 second, Your Honor, please. With respect to this argument that some of the documents requested are publicly available, I have to remind the court and the prosecutor, this is a criminal case. And while something might be publicly available, the Attorney General and the prosecutor has the constitutional obligation to produce the documentation that's in either its actual possession or its constructive possession. It's our position that defense should not be forced to bear the cost of hunting these records down. We requested it. They have a constitutional obligation to provide it, and we'd ask that the court agree. That's all I have, Your Honor, for the substance of the motion. There are some things I'd like to make the court aware of. Maybe once we conclude, just put it on the record, logistics related to proceedings, unless the court has any other questions.
I don't have any at this time. Oh,
Thank you, Judge.
thank you.
Good afternoon, Your Honor.
Good afternoon.
I'm going to address the document request first and hopefully correct some of the factual assertions that have been made here today. The defendant initially asked the people for Van Langeveld's personnel file and any communications related to the ethics opinion regarding his involvement with the case. And the people willingly provided all of that to the defendant. Van Langeveld's personnel file included his starting level and wage within the department, and it reflects that on September 18th, 2023, then Chief Deputy Fadwa Hamoud requested an accelerated step increase for Van Langeveld. And as to the reason for this raise at that time, there's a letter that explains why Van Langeveld was entitled to that raise, and it states, Mr. Van Langeveld has demonstrated the legislative and legal skills commensurate with this accelerated step increase. Mr. Van Langeveld has stepped into assisting the legislative director role as his supervisor has resigned from the position. During this time, he has performed outstanding service for the department in this legislative role. In the absence of his supervisor, he has assisted in the development of the Attorney General's legislative relations program. He has been able to advise the Attorney General, Deputy Attorney General, and other department staff in the development of policy positions. Mr. Van Langeveld has advised others in handling contacts from the legislators and their staff members related to a variety of matters, ranging from requests to formal and informal Attorney General opinions, constituent issues, development of legislation, and in coordination of relationships between the legislature and department staff, as well as coordinating the department's response to citizen requests involving consumer complaints or complaints concerning governmental entities. Mr. Van Langeveld works hard, has a pleasant demeanor, and has been responsive to the executive team and brings them issues of concern. The Attorney General and I recommend Mr. Van Langeveld for this accelerated step increase. So that is what the letter actually contains as to the reasons for this step increase. After the people willingly provided this information to the defendant, they requested some additional documents. They first requested the AG policy on initial classification of attorneys and requisite qualifications for each role and the associated salaries for each role. Those records are not held by the Department of Attorney General. They are held by the Civil Service Commission. The people did inform the defendant that they could find that information publicly available on the department's website. I'm also available to assist if that has proven difficult for them. I'm happy to show them exactly where to find the information that they are seeking. And that's more than what we're obligated to do, because that is information that is not a part of the people's mandatory discovery obligations. But I don't care. I'm still willing to help them find it if they're having trouble finding it. But in addition to that, the defendant made what was genuinely an unreasonable and problematic request. The defendant asked us to compile and provide every single request for accelerated step increase for every single assistant attorney general and special assistant attorney general since January of 2019. So a period of 5 years and approximately 4 months. Received a step increase over the past 5 years and 4 months has no relevance to whether the defendant, Kathleen Burden, or her co-defendants forged a public document falsely claiming to be a presidential elector with the intent to defraud on the date of December 14th, 2020. Now, we understand the arguments contained in the defendant's brief and the arguments that have been made today. We understand what they are trying to do, but the reality is that unfortunately they have made up a defense that has no basis in fact. And what I mean by this is rather than accept the information that is contained in Van Langeveld's personnel file about what an outstanding employee he is and the specific reasons why he received that accelerated step increase, they are trying to argue that it was improper and associated with something, I'm still not sure exactly what, associated with this file. Van Langeveld's file does not mention this case, and neither does the letter explaining the reasons for Van Langeveld's raise. And in addition to that, while I was not employed by the Department of Attorney General when this case was charged, co-counsel Ms. LaDonna Logan was, and she informed me just now that it wasn't even Aaron that charged the file, it was her. So if the court has questions about that, she's here. I'm sure she would be willing to answer them. But this is a fishing expedition. It's an effort to create a defense out of thin air that is essentially not based on facts. So it's for those reasons that we are not willing to compile all of that information for the defendant. Is not a part of our mandatory discovery obligations, nor is it something that we're willing to do. The information the defendant seeks is not exculpatory. It doesn't relate to Van Langeveld's credibility. It will not be usable as impeachment of Van Langeveld's testimony, and it really just does not fall under any other discovery obligation that the law places on the people. So it's not discoverable. I'll briefly address FOIA, the FOIA aspect of all of this. Even though this information is not discoverable as a part of a criminal case, I think it probably is FOIA-able. So if it's really important to the defense to go on this fishing expedition to look at these things that have nothing to do with the case, they have a remedy. And they can explore that if they want to, but it is not appropriate to include all of that information as a part of a discovery order.
And just so I'm clear, the only thing that you all are, it sounds like, objecting to is the compilation of the 5 years worth of step increases.
Yes, that's exactly correct. We provided Van Langeveld's personnel file as well as unredacted information pertaining to the ethics opinion about his involvement with the case. So yeah, we willingly gave that to the defense, and we'll see what they do with that.
Okay.
All right, as to Van Langeveld's testimony, a couple things to address at the outset. First, we appreciate the stipulation that the rules of evidence do apply. I personally found some of the communications to be a little bit confusing on that point. It certainly led the people to believe that the defendant's position was that we may not object to relevance, we may not object to hearsay, and we may not object to privilege. In general, I would phrase the stipulation that we reached on most of the topics that were presented to us as that all of those things are fine within reason, but that we reserve the right to object to anything that does violate the rules of evidence. And so I appreciate that clarification today, and I understand it from this point forward. Now, no court has ever held that making a defendant follow the properly applied court rules and rules of evidence when questioning a witness that they have chosen to subpoena violates due process or the right to confrontation. So that's something really important that we have to set aside before we can really even begin to talk about the proper parameters of AAG and Langeveld's testimony. There is no court that has ever reached that conclusion. So when the court places appropriate limits on his testimony, when the court follows the rules of evidence and applies privilege where it's appropriate to do so, that does not violate due process or the right to confrontation. Setting that aside and moving on to the actual disagreements about testimony, there are really very few. As I said, for nearly every topic the defendant proposed, people generally stipulated that those topics are fine within reason. And that is not trying to limit anyone's testimony or tell them how to present their case, as some of the statements in their motion seem to indicate. It's simply how it works for all parties. They get to do what the court allows them to do under the rules of evidence. And that's not groundbreaking or unfair to anyone. Aside from privilege, which I will address in a moment, there are only two general areas of testimony that we preliminarily have objected to based on relevance. And those are that we are objecting to testimony regarding Van Langeveld's personal opinion on Donald Trump and the 2020 election. And we are objecting to testimony regarding his personal opinion regarding the legitimacy of the 2020 presidential election. Any personal opinion that he holds regarding these topics are not relevant to the actions that he took as a member of the board of canvassers or as an assistant attorney general assigned to this case. Whether you hold a favorable or unfavorable opinion of Donald Trump is not something that makes you a more or credible or less credible, rather, witness or prosecuting attorney. Further, it is not a consideration for whether you can serve in a particular capacity as an attorney. The same is true regarding any opinions that he holds regarding the 2020 presidential election. Van Langeveld's opinion on these two topics are not relevant to whether the defendants forged a public document with the intent to defraud on December 14th, 2020. Whether the defense likes it or not, Your Honor, Van Langeveld just did not have anything to do with the crimes that the defendants chose to commit on December 14th. And Your Honor, there is no one in this room who is in a better position to understand that and see that than you. Because let us say, Your Honor, let's say that Van Langeveld just loves Donald Trump so much. He's his favorite person in the world. Well, how is that going to factor into your probable cause determination regarding what Burden did on December 14th? Let's say the opposite is true and that Van Langeveld absolutely hates them. Let's say that it's somewhere in the middle. Do you care about that for some reason as to whether he is credible or not? Well, and if the answer to that is no, that you don't care whether he loves or hates or feels somewhere in the middle about Donald Trump, then that is not a relevant consideration to inquire into. It's the people's position that it does not relate to an element, a defense, impeachment, or credibility, and thus it's wholly irrelevant. Your Honor, that takes us to privilege. And at the conclusion of our last day on the record in this matter, the court and Ms. Burden's attorneys held an off-the-record discussion regarding the people's motion to quash the subpoena or in the alternative grant a protective order. And this court explained to the attorneys that while it would not quash Van Langeveld's subpoena, and that ruling was part of the record that was made, that it would absolutely enter a protective order regarding the parameters of Van Langeveld's testimony. So that is what we are asking the court to do here. The defendant persists in this sort of extreme and unsupported argument that the people cannot claim work product privilege under these circumstances, and that they can ask Van Linkeveld anything that they want regarding his work product and the privileged communications that took place in the Attorney General's office. So, what does the law actually say about that as to prosecutors? And I want to start with the United States Supreme Court. Let's look at what they have to say about it. Well, in Hickman versus Taylor, 329 U.S. 495, the United States Supreme Court said, not even the most liberal of discovery theories can justify unwarranted inquiries into the files and mental impressions of an attorney. Historically, a lawyer is an officer of the court and is bound to work for the advancement of justice while faithfully protecting the rightful interests of his clients. In performing his various duties, however, it is essential that a lawyer work with certain degree of privacy, free from unnecessary intrusion from opposing party and their counsel. And our Michigan Supreme Court agrees. MRE 501 states that the common law governs a claim of privilege unless a statute or court rule provides otherwise. And there are two court rules that apply here today, Your Honor. First is MCR 6.201C, which states there is no right to discover information that is protected from disclosure by Constitution, statute, or privilege, except provided by Subrule 2, which deals with the standard for overcoming privilege, which I will come back to shortly. Second, there is MCR 2.302B3A, which protects work product that involves an attorney's mental impressions, conclusions, opinions, and legal theories concerning a case from discovery. In People versus Gilmore, 222 Mich. App. 442, the Court of Appeals held that the privilege against disclosure of an attorney's mental impressions, conclusions, opinions, and legal theories applies in the context of criminal proceedings to the work of a prosecutor. And even more specifically, the court rejected the defendant's argument that he needed the prosecutor's work product to bolster his argument that the prosecutor did not properly investigate the case, kind of similar to the arguments that are being made here today. Gilmore involved a defendant who was trying to obtain a copy of the prosecutor's disposition record, which included recommendations not to prosecute a particular case. And there's more. In People versus Holzman, 234 Mich. App. 166, the Court of Appeals held that the work product privilege protected a prosecutor's notes from witness interviews from disclosure that included portions that were factual and portions that included the prosecutor's mental impressions, conclusions, opinions, and legal theories. Now, defendant seems to argue that because AG Van Linkeveld was previously a member of the State Board of Canvassers, that all of this can be set aside, or alternatively, for the same reason that there was some type of a waiver here. Let me be very clear, Your Honor, no one has waived their work product privilege in this matter. As the court is well aware, waivers of important rights must be explicit. We do not imply them simply because opposing counsel wishes it to be so, or because an assistant prosecutor was employed in a particular capacity previously. Additionally, AAG Van Lingeveld's work as the primary AAG for matters pertaining to the investigation does not waive our work product privilege, or otherwise mean that it does not continue to apply in this matter. The Court of Appeals rejected that same argument in People versus Stuckey, number 224722. In that case, the defendant argued, just somewhat as the defendant is trying to argue here, that a prosecutor's work product is discoverable if the prosecutor acts in an investigatory role. Relying on Holtzman, the published case I previously discussed, the Court of Appeals rejected that argument and stated there is no authority for the proposition that if the prosecutor acts as one of the principal investigators, then the prosecutor's work product is discoverable. Instead, it explained that the prosecutor's privilege from disclosing work product is in fact a broad one. So, Your Honor, it is with this foundation of well-established case law regarding a prosecutor's work product privilege that we must evaluate the privilege matters the defendant believes that she can ask Van Linkeveld about, even though the work product privilege protecting Van Lingeveld's mental impressions, conclusions, opinions, and legal theories applies. The defendant claims that she can ask Van Langeveld, and this is from her previous brief on this topic, everything he knows pertaining to the case and everything he knows about the underlying facts, this case being charged, and his involvement in it all. The defendant has also argued the internal conversations regarding this case within the Attorney General's office are fair game. There is absolutely no support for this argument that she is entitled to do all of this without regard to the Attorney General's work product privilege. Now, the defendant goes on in their brief to try to rely on Detroit News, Inc. versus the Independent Citizen Redistrict Commission, 508 NISH 399 for this proposition. But that is a case that dealt with whether the commission had attorney-client privilege with their lawyers and correspondingly a work product privilege with regarding the result of that work. And in that case, they weighed that argument against the constitutional requirement that the commission must publish its data and supporting materials. Now, the Detroit News case contains a nice discussion regarding privilege, but these situations are absolutely not comparable. What the defendants are actually trying to do with no law to support their position is they are asking for even more than what the Court of Appeals said the defendants could not get in Holtzman and Gilmore, finding that the defendants can ask Van Langeveld anything that they would like to without regard to privilege would directly violate these published cases, these binding cases, which both found the defendants were not entitled to much less than what the defendant is seeking here. That does bring us to my very last point, and I promise I will sit down, MCR 6.201C. Considering the binding case law that I have described here today, there is no authority whatsoever that would allow the defendants to simply call Van Langeveld to the stand and ask him about whatever they would like to without regard to privilege. But the defendants did mention People versus Stanaway and the idea of an in-camera examination at the end of their brief. So I just want to briefly address that before I conclude. There is unfortunately also no basis for the court to conduct an in-camera examination of Van Langeveld's mental impressions, conclusions, and opinions and legal theories that he may hold regarding this case. In order to obtain an in-camera review, the defendant must demonstrate a good faith belief grounded in articulable fact that there is a reasonable probability that records protected by privilege are likely to contain material information necessary to the defense. The defendant, other than pointing to, I guess what I almost want to call a conspiracy theory that there's some kind of secret thing going on that they don't know about, they entirely failed to meet that standard. That is not a standard that can be met by speculation, or let's see what might be there. And it's also not a standard that they can meet by trying to point to other important constitutional rights that the defendant holds. We actually had a case directly out of Ingham County, People versus Davis Christian, that dealt with that very issue. There was a question of privilege that was before one of our circuit judges regarding a victim's privileged records. And the judge essentially said, well, because this is a case that involves the potential for incarceration, the potential for a defendant to be convicted, I'm just going to, out of fairness, look at this and I'll see if it's something that they're entitled to. And the Court of Appeals said, no, that is not the standard. The standard is not that this is a criminal case and that the defendant has serious rights. The standard is that there has to be a good faith belief grounded in articulable fact that there's a reasonable probability that the privileged records contain material information necessary to the defense. And so one, they haven't met that standard, but two, even if we walk down that road, Van Langeveld doesn't have anything to say that is going to be material information necessary to the defense. So for these reasons, we are asking the court to deny the defendant's motion and enter a protective order finding that Van Langeveld's mental impressions, conclusions, opinions, and legal theories are protected from disclosure during the course of his testimony. And we're also asking the court to deny the defendant's request that the people compile 5 years and 4 months of personnel records and turn over every one of the requests for an accelerated step increase from that time period. Does the court have questions for me?
I think you answered them all.
Okay, wonderful, thank you.
Very briefly, Your Honor. Let's start with quote, absolutely no support for the notion that privilege is waived. I must point out again that every single case the prosecutor cited did not have an analogous situation where a necessary fact witness was appointed as a lead prosecutor or significant to the prosecution's team. Therefore, they don't apply. To the extent that there's, again, there's no legal basis or theory for this, I'd have to again point out the Sixth Amendment right to confrontation, Brady, Giglio, all encompasses this impeachment evidence, and that's what we're after. I'm not asking either for the court to do an in-camera review of Van Langenveld's mental impressions, Your Honor. I have the reports. We have, I think, all of the reports. So what I'm specifically asking is to be able to impeach him or to ask questions of him while he's testifying, to go after that. It's beyond the report. I'm not, the defense isn't required to take the prosecutor's word for his.
Okay, specifically, what are you asking for other than this personnel file that you think is going to be helpful to the defense? Because it sounds like you think that getting information about these step increases could help show you some ulterior motive to them hiring him.
I'm not addressing the documents, Your Honor.
Okay.
I can if you, I mean,
Yeah.
the court can make its ruling on that.
Yeah, I want to talk about the documents first. As it relates to privilege, I'm pretty set on that. That I am not going to sit here and allow you to believe that he doesn't have the right to maintain privilege as an attorney about his work product. That is an absolute condition upon how he's practicing it. I can't say because he used to work in another office and he had some connection to the case and that he's a fact witness, that once he starts or takes employment as an attorney on the case, that the work that he's doing on the case is waived as to privilege. No, and that's why I made the ruling I made previously, which is I would allow testimony, but with a protective order, because I believe that his work while he's on the case is protected under privilege, but anything that he did in his role at the Board of Canvassers is not. And I'm not going back down that line. I don't care about you mismuddling things and thinking that he waived. There's nothing that shows me that he's waived privilege as it returns to his attorney-client relationship. So as it relates to that, that's absolutely denied. Now I'm trying to figure out what's going on here with the request for the documents and how do they even relate to your client's defense?
Credibility, Your Honor, or lack thereof, of Van Langenveld's incentive to join the prosecution's team.
Okay. And so you need to know how many people got in step increases before you can question this witness about whether or not he received a step increase for the work doing related to this case.
I believe, Your Honor, that under the U.S. Constitution, Brady and Giglio, that the defense is entitled to that information to attack his credibility and investigate further impeachment evidence. It's further my position that I don't have to, the defense doesn't have to take the prosecutor's word for what exists in those documents. That's the argument.
I completely agree that the defense does not have to take the prosecutor's word as it relates to finding information or getting information that you believe would impeach a witness, but I don't believe it's their responsibility to get it for you. Because the information you're requesting, compiling every single step increase under, I guess, Dana Nessel's tenure there, A, that's voluminous, but B, it's not directly related to this case. You want to use it so that you can impeach someone. That's what FOIA is for.
Thank you, Your Honor.
Even if you wanted to FOIA his personal record from his last job, see if he tells the truth or not. That's what FOIA is for. We're not going to require them to step outside of this prosecution and get you whatever it is you need to determine whether or not these witnesses are credible. That would apply to each witness that they've called. There's a multitude of information that you could get that you probably could have used to help impeach any of their witnesses that were there. It's not their responsibility to get it for you.
Thank you, Your Honor.
Thank you. So those go for denied.
Thank you, Your Honor.
Any additional matters for the record?
I don't know if we need to put it on the record, but I have a couple of things I want to highlight for the court just procedurally.
Yes.
Number one, we won't be calling Ken Chesbro for the pre-one.
You will not be.
No, so I think that takes probably a day off. I think logistically.
Yeah, how many days was it?
While you're looking at that, I was just going to mention, the court did not address the relevance arguments regarding Donald Trump and the 2020 presidential election.
Oh, I'm sorry, you're
No,
correct.
I missed it as well. Ms. Logan reminded me.
Okay, as to the relevance, you want to question the witness about his opinion, personal opinion on Donald Trump and personal opinion as to the election?
As a member of the Board of Canvassers, the deciding vote of certification back in 2020, I wanted to question him on the surrounding circumstances, the allegations being made, his awareness as it relates to those allegations, and really whether he understood, number one, that his certification could have been reversed after certification on the 23rd, which is central to the case. And then also whether he believed there was any credibility to the allegations surrounding the election. And also, I mean, you have a Republican split. So Van Langeveld is a necessary witness. So is sort of the two Democrats on the Board of Canvassers, and so is Norm Schinkel, I believe, is the other Republican. So Van Langeveld's opinions, personal opinions under 701, his impressions based on the evidence that I believe we're entitled to go into, in contrast, perhaps at a later proceeding, is all relevant to prove whether there was legitimate contention, or not even legitimate contention, amongst the Board of Canvassers as to, number one, are you voting the way you are because you hate a particular person or a particular president? Are you on one team or the other? That's what we're after, and I believe that's what we're entitled to do now.
But what in his role, doesn't his role require him to perform a function or a duty without regard for his personal opinion?
No, it was, I know they're shaking their head. The statute was amended into, I believe, 2022 to expressly sub 4 say this is a ministerial act. At the time that Van Langeveld did that, no, it was not. And that was the whole point.
But if that's the case, then how can we ever trust anyone in that role if our election results yield one thing and they can always go or make a vote based on their personal opinion?
The statute as it existed in 2020 allowed for them to adjourn certification November 23rd, 40 days from the election. By my math, that's December 13th, which was a Sunday. December 14th is the date that these allegations are proved. At that hearing, a lawyer, I can name him if the court needs to know, very well-respected Republican lawyer from Dickinson Wright, tells Van Langeveld, you can adjourn this. It's in the statute. Van Langeveld says, no, I can't. My read of the law, we can agree to disagree. I can't do this. He could have done it. I'm entitled, I believe the defense is entitled to go into that with him and get him to explain whether it's he hates Donald Trump or whatever.
What your question is, what caused him to have that interpretation?
Yes.
I think depending on how you formulate that, I think it's important to find out how he would come to that determination. Because if his testimony is that his read of the law, which what he's supposed to do, that he can't do that, I will allow you to question him within reason as to how he came to that determination. As it relates to whether or not he likes Donald Trump or not, we really don't care. We don't care if these lawyers who are representing the people that are getting charged like Donald Trump or not, because it doesn't really matter. The job is that you want to make sure your client's rights were protected and that they don't get a conviction that they don't deserve. That's our concern. We don't care if they like Donald Trump or not.
Totally agree, Your Honor.
Yeah, so it's not relevant whether or not he personally cared about Donald Trump, cared for him or not. We want to know how he came to the determination that he could not postpone this certification based on his reading of the law. That's what we want to know.
And I believe that this topic dovetails with his conclusion on the law.
You believe that the topic of his personal opinion is what's going to
I think that he would be in a position, Judge, to say in his head, I don't care what the law actually says, Charlie Spees from Dickinson, right? I've already made the conclusion. I'm not adjourning this for further investigation because I hate Donald Trump. Therefore, I'm voting to certify.
Are you calling this person from Dickinson, right?
I don't believe it. I don't. Maybe
Okay,
at a
so how are we
trial.
gonna get even to the point where you ask him whether or not he had that conversation?
Well, it goes to mental impression.
I'm sorry?
It's not hearsay. It goes to his mental impression.
Well, you're gonna ask him about this conversation. Someone advising him allegedly that he could postpone,
It's his own statements. Jen.
not the statements of the person from Dickinson, right? It's not his statement.
No, it's not. But there's without those statements, his statements mean nothing. It's not hearsay. It goes to his mental impression.
I think that you can ask the question as it relates to what formulated his ability to come to a determination that he couldn't postpone this certification without delving into his personal opinions. I don't think his personal opinions are relevant. I don't think the attorney's personal opinions are relevant. I don't think my personal opinions are relevant, especially when he's performing an essential function of the election. I think his job duties require that his personal opinion is not the controlling force. I think that's a requirement of his job. If that was the case, we'd all be in trouble every election.
And I would say his interpretation of what the law was at the time was his personal opinion, and it wasn't the law.
That's your, have you spoken to him about this?
No.
Okay, so that is your opinion without even having investigated that further, correct?
Sure. That's my opinion based on his statements and statutes as they existed at the time.
I will allow you to question him again about how he formulated his opinion, but I am not going to allow you to get into his personal opinions about the candidates, how he votes. All those things are not relevant to this. Only how he decided on that date and how he does his job in general when it comes to making a determination about certifying the election and what he believed his job duties were at that time, then you can get into that. And you can get into how he understood the statute and how he made that interpretation. But unless he opens the door for it, to start talking about his personal opinion, I'm not gonna allow you to open that door.
Thank you, Judge.
Thank you, Your Honor.
Last thing I say about logistics. So we anticipate, just so the court's aware, that Agent Shock is probably going to take a whole day. And we think AAG Van Langenveld is going to be similarly a whole day. So we would think our assumption here is that Agent Shock will be all day tomorrow. And then we would hope that we could get AAG Van Langenveld done on Wednesday.
Okay, hopefully that's how things work out.
So can I then tell AAG Van Langenveld that we'll anticipate calling him on Wednesday? We haven't subpoenaed, but if I can give him a heads up when that's going to be, I'd like to do that.
That's completely fine, because it looks like we were gonna do a Chesborough and we're not doing that at all. And so that leaves us at least an additional day to clean up and do whatever we're gonna do. You all are gonna be doing bind over or opposing bind over arguments in writing. So
Okay.
yeah, so there won't be any arguments.
Is that going to be due before the next group starts? Is it?
My recollection is it depends on when the transcripts are done, which they still are not.
Oh, they're done.
Oh, oh, well, I'm just out of the loop on that. My apologies.
Yeah.
There's a lot of transcripts.
All right.
The other party is starting next month.
So,
But will your briefs be in? Absolutely.
okay.
Your argument will be in before then.
Before we'll proceed on the next group and then hold its determination until the conclusion of that, is that?
No, I haven't made that determination yet. I haven't gotten your bind overs yet. Those could be voluminous in and of itself, just based on how this has gone. And so, but your bind over arguments will be provided before the next session starts.
Thank you, Jen.
Thank you, Your Honor.
Mr. Rothstein? I don't know if he's still there.
I
Mr.
am.
Rothstein, are you still? Oh, okay.
I'm still
My
here.
Okay, my understanding is that you all came to a resolution.
Yes, I didn't know whether we wanted it on the record or not. I thought I would just sit around to find out rather than get something wrong here.
I believe that the other party has already left, so if you're going to do, I don't know if you are doing a consent judgment, but you can just put it in writing and file it with the court.
We'll either do a consent judgment then or a 7-day order judgment. Actually, we'll do a consent judgment. Yep. Yep.
Sounds
I'll
good.
advise my client. I'm subbing in for Mr. Goldstein. I'll advise him just to do a consent judgment. I think that's probably
Okay, thank
easiest.
you. That's,
Right.
I would agree. Thank you.
Thank you.
You can have a seat, sir. Let's see. Okay, I'll amend it to 500 feet. Not to be within 500 feet of wherever the victim lives, works, goes to school, or otherwise, okay? You're welcome.
Be like get your copy of, just, oh,
You can wait outside though.
no, sorry.
Thank you.